Good afternoon, everyone, and welcome to day 2 of the 2025 ACS National Convention Series and our panel discussion, Combating a Campaign of Erasure, Upholding the Rights of Trans People to Exist and Thrive. I'm Christopher Erasure, Vice President of Policy and Program for ACS, and the moderator for today's discussion. I wanted to take a moment before we get started to acknowledge the events in Los Angeles over the past few days. The Trump administration's decision to deploy military forces over the objections of state and local officials and to detain and prosecute those who are protesting against federal immigration policies and enforcement. Though it's not directly related to today's conversation, these actions are of a type. They represent efforts to bring down the tremendous coercive power of the federal government to stifle dissent, to punish opposing viewpoints, and to deny the humanity of our neighbors, friends, and families. I'd encourage you to read ACS Interim President Zanell October's statement, available on our website. ACS will continue to speak out and work to combat any effort to silence critics of this administration. And now, a few housekeeping notes. For those of you who are registered to receive CLE for this program, you will need to submit 2 codes, which I will provide during the program, one at the beginning and one in the middle. Please write these codes down. You will enter these codes into the Google form that is also available on the ACS Convention webpage under the CLE tab. If you need help with CLE, you can always email convention@acslaw.org and we'd be happy to help you. You will also find these instructions and the code words in the chat, which you can open by clicking the chat button at the bottom of your Zoom window. And relatedly, the first code word for today's session is terrier, Terrier, terrier. There will be time during today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat to ask your questions, as we will not be monitoring it, and your questions will not be put into the queue. Today's discussion is being recorded and will be available immediately following the conclusion of this session on the Convention Series Zoom event page under the Sessions tab, along with our other previous program. Recordings of all our panel events will be available on the ACS website at the conclusion of the convention series. Now let's turn to today's discussion. On his first day in office, President Trump issued Executive Order 14168, defending women from gender ideology extremism and restoring biological truth to the federal government. This EO, which employs what can only be described as hateful euphemisms designed to deny the very existence of trans people, is not the Trump administration's only attack on transgender people, and it certainly wasn't the first attack by opponents of trans rights. To understand the context of the moment we find ourselves in and the ways in which the movement for trans rights is responding, I am incredibly fortunate to be joined by this August panel today. You can find links to their complete and impressive bios on our convention webpage, but very briefly, I am honored to be joined by Kailar Broadus, a pioneer in the trans rights movement as an attorney, activist, public speaker, author, and professor. Alana Jochum, State Policy Director with Advocates for Trans Equality. William McGinty, Assistant Attorney General with the Washington State Office of the Attorney General. And Sean Mearcamper, Managing Attorney with the Transgender Law Center. I want to thank all of you for being here today. Kailar, I want to start with you. So progress for any liberation movement is not necessarily linear and can often ebb and flow, whether as the result of hostile policies or renewed social stigma. Could you speak a little bit to the historical movement for transgender rights to provide some context for the moment that we're in now, and also how you see this moment in comparison to other moments in the movement's history?
Hello, everybody. This is a very tense moment that we're in, and I think everybody notices that. I've been in the movement for quite a while, noticing my colleagues who are with us. And this is a moment where we breathe, we don't want to flinch, but we are at a moment where it's very tense. I've been through many moments where it's been very tense in the trans movement, and I've been in the movement for some 35 years now. and through many, many tense moments and pauses. I will say this is the most tense I've been in probably every moment, and have experienced every law that we've passed, every moment that we've passed, been a consultant and engaged in every turn of events through this past 35 years or so, and been with litigators, policy people on every important piece of legislation, policy, whatever you name it, through the time. We are at a very tense point, to the point that every piece of work that's been done is being challenged now. That's where we are. We've stepped back, we've come forward, and now everything is at risk. But we don't give up. We continue fighting. And I always say that we have lots more people in the game than we've ever had before. We have more people than ever. We have the most skilled litigators. My closest friends that are doing this work, that and new people that are here doing this work that are very skilled as well. And we have people fighting like they've never fought before on these challenges that are here before. And I'll just try to tailor my comments with this. Two of my closest colleagues that are out there fighting, Jennifer Levi and Shannon Minter, who have led this movement for a long time as well. And we've all been together in this. And Jennifer just shot back to me from one of the litigations from June 6th with the soldiers that I've been involved with that are trans soldiers. And my own quote, that we are with our people always, no matter where they are. And she used that quote to energize herself as she was going into one of the litigations to the Supreme Court for our soldiers. And no matter what we do, we have to remember that we continue to fight from the Stonewall Revolution and before to now, and that we will not give up, that even though it seems like things are dire, we continue to fight. And I'll leave it there for now. I don't think we're done. And while things may seem bleak to some, it's never bleak to me. People ask how I get up every day and why we continue this. And this is why, because we don't give up. We'll continue to fight, and we'll continue these challenges. And I'll leave it there for now, Chris.
Thank you, Kylar.
Defer. Sorry.
Alana, there is this sense, I think, that in Kylar's remarks, I think, is reflected that anti-trans voices have grown much louder recently, even if popular support for anti-trans policies has not necessarily increased. Could you provide us an overview of some of the trends that you're seeing in your work in states across the country? And if you could, how these trends have built upon one another and how they're reflected in what we're now seeing come out of the federal government, particularly around Trump administration executive orders and policies?
Absolutely, Christopher. I'm so honored to be here today. And I know I have some visuals. If you want to just put those up in the background, I'll quickly go through them. But I do think it's literally illustrative of the moment that we are in to show the landscape that we are facing at the state level. The federal government essentially is copying much of the playbook that we have been seeing at the state level for years. And that has grown more and more hostile. With gratitude to our colleagues at the ACLU for really tracking this in a beautifully accessible manner, you can see that more than 588 anti-LGBTQ bills have been introduced this session, this year alone, across the country. And although they call them anti-LGBTQ bills, we know that the vast majority of them are specifically targeting transgender people. Next slide, please. The piece that I want to emphasize, much like our colleague Kylar's mandate to us, we can defeat this. we are able to. And I think it's really important to see in this slide here that although hundreds of anti-trans bills have been introduced for years now, really dating back, escalating in the 2019 year upwards, we still consistently defeat more than 90% of those bills because we show up. We do the work, we call our legislators, we educate our siblings, our neighbors, our coworkers, and legislators. We are in a really tense and difficult moment, and we are still meeting that. I never want hope to be lost. We are on track this year. This is only going through last year, but we are on track this year to defeat more than 90% of the bills that have been introduced again this year. Next slide. But I do want to just share a little bit about the trends in the bills. We have seen them evolve over the years, usually in a way where they test something. Our opposition will test a type of bill, and then they will refine it in the next session. Bills that narrowly define sex in conflict with Bostock and to try to exclude transgender people are a perfect example of this type of trend we have seen. Last legislative session, you may have heard about bills called What is a Woman bills. They were standalone. They were trying to define sex narrowly based on reproductive capacity or chromosomes or other quote unquote biological components in a way to try to exclude transgender people. And we actually hit back hard and defeated almost all of them across the country last year. This year they evolved as definition sections being put into other bills. We just defeated one of these in South Carolina. Shout out to South Carolina for defeating this in your budget bill. Ohio's pressing real hard to defeat a version of this in its budget bill. And sadly, Texas just passed a standalone definitions bill just a few weeks ago. So this is a trend, and this is echoing what we are now seeing. Well, let me be clear. Trump's executive order echoed this trend, which we were seeing beforehand. So he is copying the playbook we've seen at the state level and using executive power to try to jam through anything he can. The other types of bill types I won't get into in detail, but essentially blocking medically necessary care for incarcerated folks is a big trend. We have strong legal arguments against that. Thank you to all litigators who are fighting those bills where they have passed. Lots of oppression on and suppression of Medicaid funding to be used for gender-affirming care in a variety of contexts. Banning transgender athletes continues to be a trend. This is really sad, but it actually speaks very much to the falseness of this bill. Many states have passed this. They passed this several years ago. So why are we seeing states still trying to pass bans on sports? Because it is a talking point, and because we know that the misunderstanding around this yields lots of support for conservative elected officials. That's why we're seeing that issue be kept alive. And then finally, banning gender-affirming care for transgender youth in new and nefarious ways. We'll talk about that as we move through the panel with Skermeti as well. Just a brief overview, Christopher, on the next slide. You can see for our audience where your state falls. Advocates for Trans Equality is really focusing on the Midwest and South. As you can see here, that is where trans folks' lived daily experience is really being hindered by these terrible policies that are being passed. Next slide. And this also matches where bans on medical care for trans youth have also been passed. And then I will also end on this last slide illustrating some hope. And I think later in the panel, we'll talk a little bit more about this, but there are states that are really stepping up their game to ensure they are a safe haven for trans folks and places where folks can actually migrate to live or to receive medically necessary health care and have that care and those who provide it be protected. So we're encouraged at increasingly good shield laws being passed across the country.
Thank you, Alana. Just to follow up very quickly on sort of some of the types of legislation that you're seeing, and to the extent that the bill types that you identified could be sort of loosely described as perhaps like maybe like first generation sort of anti-trans legislation. Are there other trends that we're seeing? I'm particularly thinking of expanding bans on gender-affirming healthcare beyond just youth that you're seeing percolating in places, and what should we be aware of those efforts?
What a great question. Absolutely. The first generation that we're probably very sadly familiar with at this point, gender affirming care bans on trans youth, bans on sports access. Those are now being tweaked to be more expansive to include collegiate sports, for example, in the sports realm. Any area where a state did not cover, they're now being expanded. Gender affirming care bans we're seeing increasingly ways that they are creeping in to try to hinder access to care for adults, or expanding the age beyond 18. We know that a state has passed a ban for 19-year-olds. Other states have proposed 24 or 26 as a cutoff point. So yes, this generation, the second generation of bans is happening, and we have to be very careful for them because they're going into our family law codes, for example, trying to say, for example, that affirming your child is not going to be considered abuse or not going to be able to be considered a ground in a dispute between parents in a divorce proceedings. That's a type of bill I expect to see a lot more next session. Many of us are watching these trends very carefully, and this is actually the time that we're sort of analyzing what was introduced because it will really inform what we are fighting a year from now.
Thanks. And one other follow-up question. In terms of these types of bills, how many of them are sort of how much of them are resulting in sort of civil punishments for folks, whether it's parents or healthcare providers, and how many are actually pursuing sort of criminal penalties? And do you see a trend in sort of the ways that more of this stuff is being shifted from civil to the criminal realm? And is that something that folks should be concerned about?
I do think it's a concern. It's certainly something that we have seen an increase of bills having criminal penalties. For example, gender affirming care is for transgender youth is banned in 27 states, but 6 of them now have criminal penalties tied to at least some aspect of that care. That is a trend. It has historically been an area where we have been able to make ground and push back on. It's been an area where folks who are coming at this, let's say a little bit more honestly, have said, this isn't something we should criminalize. But depending on the trend and the mood, and right now, as we know, the Overton window has shifted for elected officials to feel but to feel a mandate to attack transgender people. It seems to be emboldening some of the penalty sections about this. I will say it is an area where we're often able to mitigate, neutralize, or defang some of the worst bills by reducing those penalty sections.
Thank you
And
so much,
Christopher,
Alana.
I know
Yes.
you're directing these to Alana, but your questions hark to previous times, and that this was directed towards trans people, and that was the intent to criminalize. And we've always criminalized trans bodies. And I do think that's the intent of the executive order and Project 2025 on the national level. And while the state bills have been coming for a while, even before 2019, that is the intent of Project 2025 and the executive order on the federal level, and it was to bridge the gap. And that's been my talking point for a while. It's the aim at youth, but it's the aim at all trans people. And so we have to be mindful of that. When it's directed at youth, it's really directed at all trans people, and it's to neutralize all trans people. And so we have always demonized trans people and trans bodies. And so that is the intent of the executive order and all of those things. And it is to criminalize trans people and trans bodies, which we really already do, even though we're not codifying it yet again, because it's really already out there. And that's the hate and the violence that trans people suffer at extreme risk. And a project that I did with Witness who does worldwide hate that did it on the state side to show how much hate trans people face in the everywhere. So, and I just want to mind that for people to see that we're just taking off the work that we've done over the last 30 years for trans people and putting these laws in place, because I want to be mindful that I am sort of the missing link, if we will, and I use that intentionally because when we started this work 30 years ago to change the face of trans people, we were at this point where we were demonized. So we were not out, we were not visible, and we were not doing this. So we were demonized, ostracized, and arrested, literally, when I came out. And so we turned the tide in the face of trans people for that not to happen, and with law enforcement and everyone. And now this tide is to change it back exactly in that way. So you'll hear many of us say all the work we've done, because there were no laws except one in the United States to protect us. And now all that work is being done to erase that or attempt to erase that to take us back to that. So, and I just wanted to point out the overall effort on the federal level to arc with the state work to make that happen. But as Alana says, we're not going to let that happen. So,
Absolutely. And I think, Kyler, I really appreciate you sort of raising that, because it goes back to the point of sort of liberation movements, the ebb and flow of the progress that is made. Because, you know, as you say, 30, 40 years ago, the criminalization of quote unquote cross-dressing and the idea that, you know, folks could be arrested simply for not meeting certain gender expectations. And we all, I think, pat ourselves on the back and say, well, that's not the world we live in anymore. But we see that we're sort of moving towards that with the idea of like drag bans and, you know, criminalizing performances in quote unquote like gender inappropriate clothing. And then, you know, trans youth healthcare bans that are actually expanding into, which in of themselves are clearly wrong, but are expanding now into the like adult sphere. I think that those sort of reflect what you're saying.
and the bathroom bans, because we're back to
Mm.
bathroom bans again, and people are ignoring those, but they're there. And so if we can get arrested in bathrooms again, which, you know, and people are taking these stories as new, but I've always been accosted in women's rooms,
Mm.
you know. And so this is where the community has to revisit these, and we have to have cross-generational conversations as well as all of these things, which is why I appreciate this panel today and you having me on this panel with other people so that we have this cross-generational conversation as well as the law conversation, because we've been here before to put this together. Exactly, because drag has always been banned, we've always been banned, and pride is a protest. So in stripping down these things to have this conversation, because we never had corporate prides, and then corporations courted us, and now they don't want to be a part of that because they're ostracized and criticized. And it's important for us to recognize and have these conversations. So,
Absolutely. Thank you so much. So, Will, I'm going to turn to you now. We're talking a lot about all the bad things that government and particularly state government and now the Trump administration is doing, that's harming trans folks. But I want to talk a little bit about the role that state AGs have served, the really critical role in protecting rights and the rule of law in both the first and current Trump administration, including, you know, within the first few weeks of this new administration, Washington State stepped up along with some other states and filed suit challenging an executive order from President Trump that purported to restrict gender-affirming care for individuals under the age of 19 and government provided insurance for such care. Could you tell us about both the order and the basis for the challenge that the Washington Attorney General and others filed in this case?
Yeah, absolutely, Christopher. And thank you so much for the invitation to speak today. Also want to acknowledge, we filed this lawsuit with the partner states of Oregon, Minnesota, and Colorado. And they were really important parts of our effort. I also need to say, I'm one person, the Attorney General's office is very, very big. And so I'm giving you my perspective today, which shouldn't necessarily be taken as the perspective of the Attorney General's office or of the Attorney General. So the order that we filed our lawsuit, along with our motion for a temporary restraining order about, was Executive Order 14187, which is, as I recall, was signed on January 28th of 2025. And this is the one, with these executive orders, you always have to use air quotes, right? So this is protecting children from chemical and surgical mutilation. Labeling gender-affirming care as various kinds of chemical and surgical mutilation. And so we brought our lawsuit with the 3 other states that I mentioned, along with 3 plaintiff physicians who the state of Washington is representing, the Washington State Attorney General's office is representing, bringing an equal protection claim, bringing a 10th Amendment claim, claiming that the executive order is unconstitutional. Because it violates equal protection rights of transgender and gender diverse patients, and also because it violates fundamentally the 10th Amendment rights of the states. The executive order, particularly in Section 4, defunds institutions that provide gender affirming care from receiving federal grants. I'll also mention in Section 5, it directs the Centers for Medicare and Medicaid Services to enact some final agency action to take away state or federal funding for gender affirming care. Our lawsuit does not, at least right now, challenge that Section 5 because we do not see CMS as having taken those actions right yet. And then there's also Section 8A, which directs the Attorney General, the federal Attorney General, to prioritize investigations against providers of gender-affirming care under the female genital mutilation statute. And we also sued on that, claiming that was a violation of the 10th Amendment, because fundamentally the president doesn't have the ability to declare a new criminal law. Anyone reading that statute would know that gender-affirming care would be outside of any definition, any plausible definition of female genital mutilation as it is defined. So we filed that lawsuit, I want to say February 7th, as I recall. And we got our TRO, our temporary restraining order, on February 14th. And then we filed amended complaints, I think the following Tuesday, in which we wrapped up also the gender ideology order, 14168, because that gender ideology order also purports to defund institutions that purport, or I forget exactly what the verbiage is, but basically support gender ideology, which fundamentally, as I read the order, is taken to mean that trans people exist, and gender diverse people exist. So obviously you can't provide gender affirming care for trans people or gender diverse people without acknowledging that they exist. So under some sections of that order, we also claimed fundamentally the same claims, that those were unconstitutional because they violated the spending clause and the separation of powers. We also got that preliminary injunction. In the preliminary injunction, the Judge King of the Western District of Washington found that gender ideology order was only supported by animus, would not even pass rational basis scrutiny. That the chemical and surgical mutilation order was subject to intermediate scrutiny under Ninth Circuit precedent and would fail intermediate scrutiny. We did not succeed on our challenge to the purported criminalization of gender affirming care, but I don't mind that because in that same order, the judge indicated that there is no plausible basis to bring a criminal charge against providers of gender affirming care. And in fact, in doing so, attorneys who would sign their name for such a thing would risk their bar licenses. That's a footnote in the order. So we perceive that as a win. We're really happy with the results so far. The preliminary injunction is now on appeal to the Ninth Circuit. Briefing in that case is stayed pending the decision in the United States Committee, which I think Sean is going to be talking about a little bit later. And the proceedings within the district court are also stayed, except for compliance proceedings, of which there have been a few, because the federal administration keeps wanting to do things that, in our view, violate that preliminary injunction order, including stripping NIH funds from some of the institutions that are providing gender-affirming care on the basis of so-called gender ideology. So that's the current status of that lawsuit.
So Will, one of the things that's been talked about with regard to a number of lawsuits against the Trump administration and some of their executive orders and actions is the application of nationwide injunctions. Could you tell me how far-reaching is the injunction in this case? Is it a nationwide injunction, or is it just in sort of the relevant jurisdictions?
It is not a nationwide injunction. It only applies to the 4 plaintiff states of Washington, Oregon, Minnesota, and Colorado. And the basis for that is we were asserting fundamentally sovereign injuries that have to do with our ability to regulate medical care within our plaintiff states. Equal protection claims are claims that are being brought by the 3 plaintiff physicians in Washington state. And so in the light of the current ecosystem where we have and the environment in which nationwide injunctions are difficult to obtain, we felt a more moderate request would be appropriate in this particular case. I will note that there's another lawsuit very, very similar to ours, T-Flag v. Trump, brought by the ACLU and Lambda Legal. And they have obtained a nationwide injunction on the basis of their organizational for the same sorts of defunding actions in the executive actions that we're challenging.
And do you know what district that case is being litigated in?
Massachusetts.
Massachusetts. Great. So acknowledging that you were one person among a staff in the Washington State Attorney General's office, and that you don't necessarily speak for the office here, I wanted to ask you, obviously, this is not the only litigation that Washington and other states are pursuing against this current administration and their actions. But for you, why do you think that it was important that Washington State weigh in here, that you use what, as with sort of like any sort of office, your limited resources to litigate this case? And what do you think is sort of at stake here?
Yeah, thank you so much for that question. That's an extraordinarily important question that really gets to the heart, of the lawsuit. And I want to emphasize, I am only one person even on this litigation team. We had, I think, something like a dozen lawyers working on this case, another dozen paralegals and investigators working on this case. And that gets right into why we had to bring it, which is because we got massive community outreach, primarily from parents, but also from trans youth and trans adults who had concerns, basically talking about how if this happened, they'd be forced to leave the United States, that they couldn't live and they couldn't raise their children in this kind of environment. I think we ended up getting something like 100 declarations from community members in support of a temporary restraining order. We got another 50 or so from community members and mental health providers and other providers in support of our preliminary injunction. And the stakes here, really, reading those declarations, and I'll be very honest and forthright here. I'm new to this work. Massive amount of respect to Tyler and others who've been doing this since I've been, in elementary school. But reading the evidence, reading the stories of people who depend upon this kind of gender-affirming care to live their lives in the way they want to live them, and raise their kids in the way they want to raise them, was the reason we had to bring the lawsuit. And this is an attack on people. It's nothing but bigotry. It's straightforwardly unconstitutional and illegal. And the weight of that was compelling.
Thanks so much, Will. Sean, I want to turn to you now. Trump v. King is one case that folks may not be as aware of, and it may be a case that's not getting as much attention as some of these other cases. And from my perspective, I might guess that it's perhaps because it's focused on individuals in federal prison, whose well-being is often overlooked or even actively disparaged. So this is a class action being brought to challenge the Federal Bureau of Prison policies enacted in response to the Trump executive order that I mentioned up top, defending women from gender ideology, extremism, and restoring biological truth to the federal government. So I want to ask you, what are the policies that are being challenged in this case, and how do these policies endanger the health, safety, and well-being of people who are in the Bureau of Prison Custody?
Yeah. Thank you, Christopher, for that question. Kingdom v. Trump is the case. My client, Alicia Sophia Kingdom, would correct you in a much sassier way than I am physically able to, just to bring her spirit into the room for a second. So this is one of the executive orders that Will was speaking about just now, the gender ideology executive order, day one, Trump administration EO. In addition to directing sort of the whole of the federal government to deny trans existence, that EO had some specific provisions related to the federal prisons. The first was to require the BOP, Bureau of Prisons, to house people only based on their assigned sex at birth. And then the second one was to ensure that no federal funds are spent on gender-affirming healthcare in the federal prisons. Our friends at the National Center for LGBTQ Rights and at GLAAD, Kyler mentioned earlier, Shannon Mentor and Jen Levi, these are their organizational homes. They ran to court on behalf of those trans women who were in women's prisons prior to the EO and were able to win injunctions preventing their transfer. That was sort of the the BOP's first attempt at implementing these provisions. And then our case sort of followed on as a class action aimed at protecting folks' health care. I think it's really important for folks to understand sort of the background facts around trans folks who are in prisons around the country, but as it relates to here in the federal prison specifically. Because to hear the right wing tell the story, or even most media tell the story, I think a lot of casual observers might have the misimpression that, for example, that most trans women are housed in women's prisons, which is absolutely not the case. Or they might have the misimpression that access to transition-related surgery is sort of readily available for incarcerated folks. Also, very much not the case. Numbers are not my strong suit, but bear with me because I'm going to throw some at you. So there's about 155,000 people in federal prisons around the country. Of that 155,000, according to BOP, there are 1,028 folks incarcerated in federal prisons who have gender dysphoria diagnoses. Of those, 628 are on hormone therapy. And then even fewer than that, there are fewer than 20 trans women who were in women's prisons at the time of this executive order being signed. And then I don't have exact numbers on this, but we could count on one hand the number of folks in federal prisons who have accessed transition-related surgery while incarcerated. So those are the background facts, and that is the sort of very small subset of people who this executive order was targeting with its provisions on the federal prisons. So day one, this executive order was signed. Implementation was sort of chaotic and uneven. Some people did have their hormones cut off. Some people had them were started on a tapering regimen to be eventually taken off their hormones. But what we heard most commonly from incarcerated folks was that they were being told as soon as your current prescription runs out, you're done. And then much more widespread, then all of that was the actual sort of revocation of sort of gendered clothes and undergarments that folks had previously been issued. Trans women in men's prisons having their bras confiscated, being forced to walk the men's prison, not wearing bras, being gawked at, being even further sexually harassed than they're already used to. Transgender men being forced to wear women's underwear, right? Just really horrific situations. Transgender Law Center with the ACLU and the ACLU of DC, we brought suit in the District of DC. Our clients are named plaintiffs, Alicia, Jazz, and Solo. They are the best clients you could ever ask for. They are just like outstanding leaders in their community and the facilities where they're housed. They are class representatives. We brought a number of claims, but last week, on Tuesday of last week, we won class certification and we won an injunction on Administrative Procedure Act grounds. The judge sort of laid out very clearly that there was zero reasoned decision making behind BOP's efforts to implement this executive order. And that what might pass for reasoning in the executive order cannot substitute for what's required of an agency. My favorite part was when the judge pointed out that, like, by taking your medicine, you are not expressing any ideology. You are just taking the medicine that you need to address your health conditions, right? And so again, working with these folks who are just put through the ringer again and again in the federal prison system, they just are just so impressive in how they are able to sort of keep things together and to move forward pieces of a movement despite all of that. And I think that, you know, Alana and Kyler have already sort of alluded to it, but working on this case has showed me that again and again and again that when we fight together, we win.
This may be a little bit of a leading question, Sean, but it seems to me in this conversation, we're talking pretty frequently within an already vulnerable community about particularly vulnerable sub-communities like youth and people who rely on Medicaid and people who are incarcerated. Do you think it's a coincidence that President Trump's day one executive order specifically called out prisoners and trans prisoners who are a vanishingly small number of people in the Bureau of Prisons population, in that moment, or is there some sort of method behind the cruelty?
No. I mean, I very much think it's intentional, right? And we've talked about how these bans on trans youth healthcare are just the beginning, right? And so so first you ban youth healthcare because they're vulnerable and need to be protected and they're not old enough to know what they're doing, which is ridiculous in itself, right? And then you start in on the adults by coming for poor folks' health care because who wants to pay for that? And for incarcerated folks' health care because they're invisible, they're behind walls, and no one wants to pay for that either, right? But but what happens in the prisons never stays in the prisons, right? When the last administration put out a regulation on trans youth sports that included case-by-case language, case-by-case basis language, like my first thought was that's what they do in the prisons, right? And so if we care about anybody's rights, we have to be caring about incarcerated folks' rights.
Thanks, Sean. I also want to ask you about another case that is currently before the United States Supreme Court, and I would hazard to say that I think it's probably going to be the highest profile case related to transgender health and well-being that will be decided this year, and that's US v. Scrimetti. And this is a case that's challenging Tennessee Senate Bill 1. Sean, could you talk about what Tennessee Senate Bill 1 is and what the challenge is and sort of what the basis for that challenge is?
Sure, and I'm sure everyone here has lots to say about this case. So just to sort of set the table, and then hopefully other folks will jump in. Alana mentioned earlier, 27 states banned trans youth healthcare. This case is about the version of that ban that happened in Tennessee, SB1. There have been challenges to these bans all around the country. Scrimetti is the case that made it to the Supreme Court. Again, to like step back and think about sort of the background facts and sort of the broader understanding of this issue, I think it's really important because even in media outlets that are generally considered progressive, I think that there's been way too much whataboutism with trans youth healthcare recently. And so in part because of that, Transgender Law Center and some amazing partner organizations put an amicus brief into the Supreme Court, lifting up the voices of 6 trans youth leaders, explaining sort of how gender-affirming healthcare saved their lives, because those are the voices that matter, and those are the voices that the Supreme Court should be hearing when making this decision. This decision could be coming out sort of as soon as tomorrow. It's expected sort of this month. The case, like, again, many companion cases in other states, was brought on equal protection grounds, but also on due process grounds. Due process, in this case, being the sort of right of parents to direct the upbringing of their kids and to make medical decisions for their kids. For reasons we'll probably never know, the Supreme Court only took the equal protection question. And so the implications, whatever the decision is, the implications are going to be far-reaching, right? There has been a really sort of frustrating trend in these cases around the country where these laws are very explicitly sex classifications, right? The Tennessee law, for example, like it defines sex, and it defines sex to exclude trans folks. And so it is tautological that these are sex classifications, and yet decisions around the country have sort of grappled with whether or not these are sex classifications. They very obviously are, and so it is an open question whether the Supreme Court is going to apply any level of scrutiny to this case, and whether or not it's going to sort of understand the literal words on the page as to whether this is a sex classification. But I think, again, sort of zooming out for a second, right, the legal question in this case is about equal protection, but I think that the much bigger question for like that everyone ought to be really concerned about, the question I think the court is answering is can right-wing extremists make up lies about the healthcare you and your family and your kids need, and then use those lies to ban it, right? RFK Jr. is our HHS secretary right now. And folks are already, I think a lot of folks are already scared about that, right? But the playbook that the right wing has put in place around these bans around the country, in the legislatures and in the courts, it's not just about trans kids, right? It's about all of us.
Thanks, Sean. And I would open it up to any of the other panelists who might want to reflect on Scrimetti briefly. Okay.
Well,
If
I'll jump in real quick,
please.
Christopher. Sean is so right on. There's really nothing else to say after Sean's spoken. So great job, Sean, and Will also. But I will jump in on the case involving and I'm sorry I froze. Uh uh and I'm sorry, I'm blanking here, but incarceration is what I want to say. And all of it's so important. Healthcare is very important. And I pause, and Sean, that was all great. And so was the incarceration. But I want to point out that VAWA was touched as well, the Violence Against Women Act. So it's touching all vulnerable communities that intersect. So we, want to talk about intersectionality and how, this administration is not understanding intersectionality, nor does it want to understand intersectionality, and how our communities are all defined with intersectionality. And the people that are most impacted by intersectionalities are the communities that are most attacked by this administration, and trans communities are impacted by intersectionalities on all levels, whatever the intersectionalities be, but particularly the prison populations, which I deal with all the time. And you can't get your medicine regardless of what it is. And that's the problem. And so people are punished for getting their medicines when you go into the prison system. And, we were working on that with VAWA and other avenues and working on fixes for that. And then this totally disrupts that and impacts people's abilities, all levels of abilities to function in the prison populations. And so I think that is dramatic and devastating on many levels. So.
Thank you, Kyler. I want to remind folks that if you have a question for our panelists, click on the Q&A button at the bottom of your Zoom screen, type in your question. We'll be looking at those, and we're happy to ask those of our panelists. I also want to give the second of our two CLE code words. The second CLE code is Bulldog, BULLDOG. There's a little theme going on. If you were here last week, maybe next week, you could guess what some of these code words are. With that, I did, we've talked a lot about the problem, and we've touched a little bit on sort of like what folks can and are doing to address this problem. But, one of the things we do want to do is give folks some information about ways in which they can sort of contribute to a movement to protect trans folks, and what's currently being done. So Alana, I wanted to turn to you first. You had mentioned earlier in your presentation that some states have enacted shield laws to protect access to gender-affirming healthcare. Could you explain a little bit about how those laws generally work, and whether there are other measures that states are or could take to affirmatively protect trans people, both in their own states and sort of outside of their states, transgender folks from perhaps more hostile states?
Absolutely. We have seen a growing trend in the last several years of states that have the political ability, the political will, to become what is called now a shield state. And these vary in their strength, in their approach, and in their effectiveness across the country. But currently there are 14 states that have passed shield laws, plus the District of Columbia. New Jersey and Arizona have enacted them via executive order. So it's a very interesting place in Arizona where the legislature is very conservative, but the governor is very progressive. And so it's almost a split experience there. But essentially, what is a shield law? They try to do generally three things. They first try to protect patients who are receiving medically necessary care and services that are legal in the state in which they are traveling to, the state that is passing the shield law. They're also intending to protect health providers, the people who are giving that care, to perform those legal health care within that state. And then third, they're trying to protect third parties that are supporting access to the services. We know that we have seen a trend of trying to sometimes criminalize or otherwise sanction to scare off people who would help people to receive medically necessary care, whether that be abortion or gender-affirming health care. And these are trying to also curb and fight back against that. I think I do want to clarify, especially for folks who are listening, this is different than if you've heard about sanctuary cities. That also was a trend, continues to somewhat be a trend, but a sanctuary city is a situation where you have a city in a very conservative state trying to declare and protect within the bounds of its city access to certain care. And unfortunately, that is not actually as effective. Sanctuary cities, you can't, as a city, for preemption reasons, choose to not follow state law. You can push back in certain ways. You can prioritize your city resources. You can make declarations, certainly, of how you oppose a state law or affirm you will do everything within your power to protect trans folks, for example, in your city. But you can't actually not follow the state law in most situations. So I would say we have celebrated the intent behind sanctuary cities, but discouraged an investment of resources in that because it can actually provide false hope for folks who are living in deeply conservative states and thinking that they are somehow legally more safe in another city than they may actually be. We love that places all try to create the lived culture. We often talk about legal equality and lived equality. We all can improve the lived equality wherever we live. And that's one of the other things that we need to double down, no matter the ruling in Scrimeti, no matter what we see from the federal government pushing down. A reminder too, executive orders are not the law. They're not the law to the degree that they are out of alignment with actual laws. And here we are seeing that constantly pressed, not just in our area we're talking about today, but so many of the Trump executive orders. It's clearly a declaration of the policy he wants, but it's not actually the law until other things change. So I think this is really an area that states can invest in. And Will, it was so encouraging to hear from you and about the pushback through legal actions of condemning some of these far-reaching and illegal executive orders. I think that's the advice that we would give to states and elected officials. Use your power to pass laws that protect trans folks. If you're in a state where you don't have the numbers physically to do that, be visible, make statements, and be clear that you are an ally to the trans community, especially as we see Scrimeti come down, no matter what it says, and use your power to try to effect change in every way possible, whether that's defending against these terrible anti-trans laws coming down at the state, or to proactively codify, for example, your executive order if it's a shield law. I'm sorry, your shield law if it's an executive order right now, or improve and strengthen it in ways with working with legal advocates.
Thanks, Alana. And I will take moderator's privilege very briefly to say, if you want to learn more about executive orders and the extent to which they are or are not legal, there is a post that I wrote on ACS's In Brief blog that provides a bit of an explainer. So if folks have more questions about that, you can take a look at that. Kyler, I want to ask you, so in any movement for liberation or civil rights, I think the members of the affected community must be empowered to lead, to set the agenda, and to speak to their community's needs and the goals of the movement. And that's not to suggest that any community is monolithic in its positions, but how are you seeing trans communities respond to this moment, particularly at the local and state level? And how do you think folks who may not be members of that community but want to be allies, effective allies, how do you think that they can contribute to sort of that movement and the work that those activists are doing on the ground?
Well, Christopher, that's a very good question. And it's different from how it used to be, because when we first started organizing, we didn't believe there were 10,000 of us, quite frankly. And, I was part of that. So that is a good thing because movements are not monolithic. So the first thing I tell people is get out of your comfort zone, especially if you're not part of the community. And what does that mean? Look around. If you don't have trans friends, make them. Okay, where can you do that at? First place is there a community center? Look online. There's plenty of information online that is the correct information online. You just have to search. I actually just had, while I was at another event last night arranging a press event, I had an old family friend that was on Facebook giving out false information that he had picked up from this administration. And I said to him, you need to get the correct information. One, he could go to my Facebook page, but he refuses to do that. So, where I put out lots of information. I've been in Hacktives forever. But if you don't do that, there are plenty of resources that are available. Some of these organizations that are on here, not mine anymore, because I consult for various organizations. But there is Advocates for Trans Equality, Transgender Law Center that's on here, and the Human Rights Campaign. I mentioned two, although I didn't name their organizations, but Sean did when they spoke, rather, pardon me, Sean, which is GLAD, 1A, GLAD, National Center for, I forgot, NCLR, rather, who has done advocacy, HRC. Look for organizations that do the work, and PFLAG, for example, is another organization where you can get information. You can write down some of these names and get information, or local organizations in your community, or people that you know that are doing the work. Those are some of the ways you can do some research on your own, get some information, pick up friends, go out with a friend, make a friend. But here's the other thing. You have to do the work too. And that's where we get the most benefit. And that's where I've gotten the most benefit is when allies do the work. You supplant us or replace us in our shoes. And that's the biggest benefit of the work. And that's actually what I learned working in the civil rights movement is allies, how to use them effectively. And I've used them in this movement as well, the LGBTQ movement or trans movement. And so allies learning to do what we do. And there are trainings that you can learn that at. And the last thing I'll say, or near last thing I'll say, is choosing what you do, whatever's at your comfort level. And sorry, I'm not looking into the camera. This is what I tend to do when I think. But what is comfortable for you? Is it just giving money? That's fine. We'll take your money. But also, we would like you to engage. Is it coming out to a protest with us? We need people to press the grass right now, press the pavement, whatever it is. We need you doing that. We need you out there. Can you give us some research? Can you give us some time? Can you go visit some of us that don't like to come out? Actually, I don't, as much as I talk in public. I'm an introvert, so I don't like to come out. I need friends to come visit me sometimes. There's all sorts of stuff you can volunteer in the community once you get out and get involved. Those are the things we need you to do. We need you involved. Okay. And legal research, law firms, all those sorts of things. We need people at every level. Okay. Volunteering, visiting people in prison. We've got it all. We need you. We need your help. Now is the time. Do not sit and wait. We need you.
Thanks, Kyler. There's definitely plenty to do.
Exactly. Did I make that clear?
You did, and I appreciate it. I love a laundry list. I think that's
All
great.
right. All right. There's plenty to do.
So, Will, I want to
Was there
ask you.
another question? I'm sorry. I just wanted to make that clear. We need people and we need all the help we can get.
Absolutely. Absolutely. So, Will, I wanted to ask you, in addition to the litigation that state AGs are pursuing against policies like the the ban on gender affirming healthcare, what other efforts are you seeing, or do you think that state attorney generals and other state officials can undertake to support and protect the trans community? And I think relatedly, what message do you think is most effective for folks who support trans rights to communicate to their state officials?
Yeah, so again, big disclaimer, I'm just one dude. So in terms of state AG's offices, this is a nationwide convention. AGs have different statutory authorities and abilities across the country. You know, I'm kind of privileged to be in the state AG's office that has a significant amount of statutory and constitutional authority under our state laws. But the one big thing that comes to mind in my mind is enforcement of civil rights laws. So states have their own civil rights regimes. I know Washington is, particularly strong, and other states have particularly strong civil rights regimes. Just had a case come out of the Ninth Circuit that came out of one of those, Olympus Spa, relating to a purported First Amendment right to keep trans people out of a particular health spa, which was denied by the Ninth Circuit. And so that was Neil Luna of our office who did that, who was also in the team doing our litigation we're talking about today. And so there's that. There's enforcement of civil rights issues. There is potentially public information. So I know that our office does kind of know your rights pamphlets. We have one on gender affirming care on our office's website. Some of the shield laws that Alana was talking about can kind of be complicated, and we don't do very much unless people know what they are and know what they say. And so the efforts by state actors who have some responsibility to informing the public about what the laws are and how they can take advantage of them is another avenue that I've seen, particularly our office and other offices nationwide, make an impact, let people know what their tools are. And then in terms of, letting people talking to your AG, I mean, I'll emphasize again, one of the big reasons that we brought the case that we're talking about today was because we got concerned calls, hundreds of concerned calls from parents and trans kids and trans adults who were deeply worried about the efforts that the administration was taking. And that was very impactful in showing us that this, gave Washington State a legitimate basis to challenge the constitutionality of the orders, and that we needed immediate relief to stop them from going into effect. And so I guess what that tells me is, tell your AG what you need and why. And hopefully, they'll listen to you and they'll figure something out.
Thanks, Will. We're almost at time. We will have a chance to we'll all have a chance to speak to at least one of our panelists in our talkbacks, which are going to start in a moment. But Sean, I did want to give you a chance if there's sort of anything you want to add as we wrap up, whether it's sort of litigation that's percolating that you think it's important that people are aware of, or anything else that you want to reflect on before we wrap.
Yeah, just real quick. I haven't been around as long as Kyler, but long enough to notice shifts and trends. And so just one thing I want to make sure folks are aware of is that 5-6 years ago or so, our primary sort of legal opponents, their position really was just that laws and jurisprudence around sex discrimination don't cover trans people. Sorry, you're out of luck, right? That was really the extent of the opposition. And fast forward to today, they've gone so much further because now they're saying that laws and jurisprudence around sex discrimination require trans exclusion. The new head of the DOJ Civil Rights Division sort of brought several cases along those lines in private practice before her current appointment, and so. This is just popping off in California. The AG there filed preemptive suit, I think it was yesterday, around a threat from the federal government along these lines. So that is just one thing that I think folks should be keeping a very close eye on going forward.
Our network is growing to meet this moment. Since the start of 2025, we've had interest in new or revived student chapters at 15 universities and new lawyer chapters in 6 different legal communities. Check out our website and find your local ACS community. Now, we'd like to take some time to recognize a few of our exceptional student and lawyer chapters.
Thanks, Peggy. First, we're going to recognize our ACS Student Chapter of the Year. This award goes to the chapter that has shown the greatest overall strength in meeting ACS's mission and goals. This year's winner is the Arizona State University Sandra Day O'Connor College of Law. The chapter has worked closely with the local lawyer chapter and other student chapters to host a number of events which covered the influence of Indigenous communities on the founding of our country, presidential powers, the death penalty and mass incarceration, reparations, immigration, the role of prosecutors, and more. Congratulations to the ASU student chapter.
And next, we have our Rising Student Chapter of the Year. This annual award goes to a new or recently revived chapter that has done the most to advance progressive causes. This year's winner is Wayne State University Law School, which quickly scaled up and hosted programs examining voting rights, labor organizing, LGBTQ+ rights, race in the law, and more. Their program successfully facilitated strong connections between student members, faculty, and within the local Detroit community. Now, Faculty Advisor of the Year. This award recognizes an ACS faculty advisor for their support of ACS and their local student chapter. This year's awardee is Professor Kent Greenfield of Boston College Law School. We are grateful for Kent's commitment and dedication to our network, ACS's initiatives, and the BC Law Student Chapter over the years. He supports our ACS leaders across the country, visiting chapters near and far, and works to consistently activate the progressive legal network. Kent recently organized the Law Scholars Letter, declaring that our country is in a constitutional crisis. This garnered over 1,000 signatures.
Turning to lawyer chapters, we'll present our award for Lawyer Chapter of the Year. This year's awardee is the San Diego Lawyer Chapter. This chapter has excelled in expanding and strengthening the progressive legal network in San Diego. We're thankful for their work in engaging and activating local lawyers and educating the community on immigration law, employment law, workers' rights, and more. Next, Rising Lawyer Chapter. This year's awardee is the Nebraska Lawyer Chapter. Only recently revived, the Nebraska Lawyer Chapter has worked to facilitate strong connections between not only local lawyers, but also by engaging ACS-affiliated students in the states and other local progressives. We're thrilled to see their momentum grow. Now, the ACS Programming Awards. These are presented annually to our most active and engaged student and lawyer chapters. We're thrilled to present this year's awards to the Bay Area Lawyer Chapter, the Washington, D.C. Lawyer Chapter, ASU, Universidad de Puerto Rico, Georgetown, Harvard, Notre Dame, Rutgers, the University of Chicago, the University of Texas, Duquesne University, University of Alabama, University of Cincinnati, University of Kansas, University of Michigan, Penn, UVA, University of Wisconsin, Wayne State, and Yale.
Lastly, we're happy to announce the winners of the Richard D. Cudahy Writing Competition on Regulatory and Administrative Law. This competition celebrates the late judge's distinguished contributions to the fields of regulatory and administrative law. Judge Cudahy, who passed away in 2015, was appointed by President Carter to the United States Court of Appeals for the Seventh Circuit, where he earned a national reputation for his keen grasp of legal doctrine, deep insight into the institutional forces that determine how doctrine is implemented, and an appreciation of the public impact of doctrinal and institutional choices, including the consequences for fundamental values such as fairness, participation, and transparency. This competition seeks to encourage and reward these qualities in the scholarship of others. The lawyer winners for the Cudahy Writing Competition goes to Jody Short, the Mary K. Kane Professor of Law at UC Law San Francisco, for her piece, The Moral Turn in Administrative Law. The student winner goes to Ari Goldstein, a 2025 graduate from Penn Law, for his piece, The Lost World of Jurisdictional and Constitutional Facts in Administrative Law. Thank you to our network members for creating a positive dialogue for change at their universities and in their communities, and for working to advance progressive legal principles. We're so honored to work with you all and so very grateful for your contributions to ACS's mission.